Therefore, now let's kindly come to the argument. I've done with the dissolution part. I've done with 356. Your lordships have read all the judgments, I'm not going to repeat anything. Now I come to the argument of impossibility. An argument not raised, not part of the counter affidavit, not part of any pleadings, not part of any proclamation, not part of arguments the last time also, not part of the first set of written submissions, and yet we have to deal with it. Now, let me tell you, lordships, the principle of impossibility, constitutional principle. I'll just enunciate it. If there is a constitutional obligation to be performed, and it has to be performed, then in furtherance of that constitutional obligation, the principle of impossibility of performing another obligation comes in. Give your lordships an example. The term of the assembly is 5 years. Assembly is dissolved in 4.5 years. There is no assembly. And the judgment my learned friend cited, there is a presidential election or election of the vice president, and members of assembly have to vote. But the term of the assembly expires in 5 years' time. The Constitution says you have to perform that obligation. So if the assembly is in dissolution, it's impossible for them to vote. That's the constitutional principle. Where is the obligation under 370? It has to be stated in the Constitution. You can't silently invoke it. And 376 probably free bill may, not shall. There is no obligation. That's the principle of impossibility, which has absolutely no application. How is it impossible, Malad? Why is it impossible? No, you've made it possible by acting the way you've done. That's the way to do it, Malad. Now, whether that's constitutional or not is a definite issue. But it's certainly not impossible. If you uphold it, it's not impossible. If you don't uphold it, it's only unconstitutional. Beyond that, your lordships are not asked to decide. So where is the question of impossibility? Where is it? Page 27, PDF, page 27. Volume? Yes, my rejoinder, PDF 27. I mean, it's just, I've already argued it, Malad, that this is all beyond, Malad, the powers of the president. And in any case, he has to act on the aid and advice of the Council of Ministers. So Parliament also has nothing to do with it. And Malad, it doesn't need concurrence, doesn't need consultation. That argument I've already made. And if that can't be done, Malad, then we're left with nothing. Then 273. No. Let's 273 now. But let's also kindly note. Nothing else. Oh, one second. 36. let's kindly come to my the 367 argument that was made. The interpretation part. And then they relied upon Damnu Malad. That argument has already been made. I'll not repeat it, Malad. Damnu itself says that this particular change at that point in time was not a change in the substance of 370. In the Jammu Kashmir constitution is applicable, the word governor was already there. And therefore, you couldn't have interpreted it in any other way. So that's all, Malad. It's already been argued. Now come to Malad to Article 3. PDF 33. So, Malad, as far as Article 3 is concerned, Malad, let's assume I've made my arguments on the proviso already, Malad, that under 356 it can't be done. But now let's assume the proviso is not there. Let's assume that, Malad, all this is valid. Let's assume. Malad, how can they make the union, a state into a union territory? Under what provision of law? Okay, under which, what power? Then my Lord put to them that there may be a situation of a national security situation. So therefore, temporarily, you may need to do that. But the national security situation is dealt with by Article 352 of the Constitution. 352 to 359 deals with all this. So how can you use Article 3 to do that?